Hello everyone, I'm Debojit Das and welcome to Courts Today by LiveLaw. The holidays might be approaching fast, but the courts across the country were busy as ever. From mental health concerns in IITs to judges rebuking lawyers for hooliganism. From delayed election petitions to new ground on maintainability issues, a lot happened today. So let's get right into it. Starting with some important update from 26th September as the Supreme Court stepped in on a very sensitive case involving a student from IIT Kharagpur. The student has been diagnosed with borderline personality disorder and depression, has asked to be transferred to IIT Delhi so he can access specialized treatment at AIIMS and can also be closer to his family for support. In his plea, he says his mental health is deteriorating in Kharagpur and points to the Supreme Court's earlier Sukhdev Saha ruling, which recognized mental health as an essential part of the right to life under Article 21. Since IIT Delhi does not offer the architecture program that he is currently pursuing, he has requested a shift into an equivalent BTech course based on his JEE rank. The Supreme Court has now issued notices to IIT Kharagpur, IIT Delhi and AIIMS asking for their response, with the case coming up again on October 10th. But here's why this plea has drawn wider attention. IIT Kharagpur has already reported 5 suspected student suicides this year alone. That number has sparked serious questions about the mental health crisis inside India's premier institutes, where academic stress, isolation, and lack of adequate counseling are pushing students to a breaking point. The court's intervention signals that mental health in education cannot be sidelined, and institutions may soon have to do much more to protect their students' right to life, dignity, and well-being. Staying with the Supreme Court as it reprimanded 2 Delhi judicial officers for granting bail to a couple accused in a multi-crore scam, describing their actions as untenable and bordering on perversity. In November 2023, the Additional Chief Metropolitan Magistrate at Karkardooma granted regular bail to the accused after the charge sheet was filed. This decision was upheld by the Sessions Judge in August 2024 and later by a single judge of the Delhi High Court in November 2024. However, the Supreme Court found that the accused had misled the Delhi High Court by concealing the rejection of their anticipatory bail applications while seeking regular bail. The court criticized the ACMM's simplistic approach, noting that granting bail merely because the charge sheet had been filed overlooked the dishonest conduct of the accused, who had violated earlier undertakings given to the High Court while enjoying interim protection. Furthermore, the Supreme Court pointed out procedural irregularities, including the investigating officer's failure to seek custody and the judicial officer's disregard for superior court rulings. As a result, the court set aside the bail orders and directed both judicial officers to undergo a minimum of 7 days of special judicial training at the Delhi Judicial Academy. The training aims to sensitize judicial officers on conducting proceedings and adhering to superior court decisions. It shows the importance of judicial accountability and adherence to legal procedures, especially in cases involving serious allegations, cannot be loosely observed. Next, we move to a controversial development in Jharkhand as the Jharkhand High Court has sharply reprimanded Advocate Rakesh Kumar for conduct that crossed the boundaries of courtroom decorum. The incident occurred during a hearing on an anticipatory bail plea in a land grabbing case when the advocate reportedly spoke in what the court described as loud speech. And not just that, he allegedly threatened the court, saying, "Pass the order or I will go to the Honorable Supreme Court." The presiding single judge did not mince words though. He called this behavior hooliganism in the name of advocacy and stressed that open court is not a place for threats or shouting. It's a forum for reasoned and respectful argument. The court reminded all legal professionals that decorum and dignity are fundamental to the justice system and cannot be compromised with. The judge also highlighted that even a single judge has full powers to punish for contempt under Section 15 of the Contempt of Courts Act, and made it clear that lawyers are not immune from these powers. In response to Advocate Kumar's conduct, the court ordered him to tender a formal apology and imposed costs as a corrective measure. The key takeaway here: respecting the dignity of the court is non-negotiable. Loud arguments, threats, or attempts to intimidate the bench will not be tolerated, and repeated misconduct could attract stricter punishment. The ruling serves as a strong reminder that advocacy must always be exercised with professionalism, even under pressure. Next, in an emphatic ruling, the Bombay High Court has held that marrying the victim and even having a child does not erase offences under the POCSO Act. The case involved a 29-year-old man booked under POCSO and the Prohibition of Child Marriage Act after it came to light that he had a relationship with a minor girl. Later, the families approved their marriage on June 2nd, 2024, following Muslim rites, and the couple had a child. Despite this, the accused sought to have the FIR quashed, arguing that their marriage and parenthood should close the case. The division bench, led by Justices Urmila Joshi Phalke and Nandesh Deshpande, rejected this plea. They emphasized that sexual offences against minors are statutory safeguards designed to protect children regardless of later consent or family approval. The judges noted that personal relationships changing after the crime cannot override the state's duty to prosecute serious offences. They also stressed that courts cannot allow procedural shortcuts just because the victim and accused later married or had a child. Accountability and the protection of minors must remain paramount. The ruling reinforces a crucial principle. Marriage or parenthood after the fact cannot become a shield against prosecution under POCSO. Moving on to the Madhya Pradesh High Court, as it sharply rebuked the state for appearing to shield one of its ministers, Govind Singh Rajput, over allegations of concealing massive assets in his 2023 election affidavit. A petition claims that Rajput failed to declare 64 plots of land and other properties worth hundreds of crores, while his affidavit reflected only about 12 crores. During the hearing, the state tried to justify delays by saying election petitions take 5 years. The court, however, did not hold back, retorting that when the ruling party is involved, it's 5 years. When it's not, it's 5 months. The judges made it clear that deliberately withholding information from the Election Commission to protect a minister is unacceptable. The High Court has now issued notices to the government, the Election Commission, and Rajput, demanding an explanation for the discrepancy between property records and the affidavit. The key takeaway here being, holding public office does not give anyone a shield to hide assets, and transparency in election disclosures is non-negotiable. This case also highlights concerns about how quickly or slowly government machinery works when vested interests appear to be involved. Next, the Himachal Pradesh High Court has commuted the death penalty of 2 men convicted in the 2014 kidnapping and murder of 4-year-old Yug Gupta, while acquitting the third accused. Back in 2018, a trial court had sentenced all 3 to death, calling the crime rarest of the rare. The prosecution alleged that Yug was kidnapped, tortured, and thrown alive into a water tank. His remains were found 2 years later, sparking public outrage. But Justices Vivek Singh Thakur and Rakesh said the evidence does not fully support that version. They noted serious gaps: no clear account of what happened between the kidnapping and recovery, weak reliance on circumstantial last seen evidence, and doubts over the diatom test used to claim Yug was drowned alive. The bench stressed that while the crime was horrific, courts cannot impose the ultimate penalty without proof of unmatched brutality and irrefutable evidence. Instead, they reduced the punishment to life imprisonment till natural death, ensuring the convicts never walk free. For co-accused Tejinder Pal Singh, the court held the charges were not proved beyond reasonable doubt and he was acquitted. The ruling is a reminder that even in deeply disturbing cases, death penalty requires extraordinary proof and justice must rest on evidence, not outrage. And finally, the Allahabad High Court has ruled that applications for maintenance under Section 125 of CRPC can be filed against minors, rejecting the argument that only guardians can be held liable in those cases. This decision arose from a case where a 13-year-old boy married a girl, and 2 years later, they had a child. At the time of the maintenance application, the boy was about 16 years old. The family court had awarded 5,000 rupees per month to the wife and 4,000 rupees per month to the child. Challenging this order, the boy's counsel argued that since he was a minor, the application should have been filed through his guardian. They also contended that the wife was not entitled to maintenance under Section 125 subsection 4 of the CRPC because she had refused to live with him without reasonable cause. Justice Madan Pal Singh observed that Chapter 9 of the CRPC does not specify that applications against minors must be filed through their guardians. Section 125 CRPC allows any person with means who refuses to maintain his wife or child to be liable for maintenance. The court noted that while the boy was a minor at the time of the application, he had attained majority by the time of the judgment. And that wraps up today's edition of Courts Today. From critical interventions on mental health in IITs to clarifying legal accountability for minors, POCSO protections, and public office transparency, the courts were busy shaping law and justice across the country. Visit www.livelaw.in for comprehensive updates on all these cases and much more. Until next time, thank you for watching.